Let's talk about protective orders. What is the burden of proof? My name is Carl Birkhead. I'm an attorney with Worth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for almost 8 years now, and I want to help you make law easy by just talking a little bit about what you need to do to be able to actually prevail in a protective order case. So I actually had this come up recently where um, I had a client who was wanting to seek a protective order, and I genuinely believe that she was entitled to one. Here's the problem, though. The facts and the allegations were the type of facts that it was almost impossible to prove. There was no actual forensic evidence. There was no bruising, no marks, no DNA, no uh, you know medical records from hospital visits. I mean, there was literally nothing other than just my client saying that it happened. And obviously, the other side said no, it didn't. So it came down. I mean, in those types of situations, it kind of comes down to the credibility of the witnesses and who's more believable. But here's the problem: the burden of proof in these situations is on the plaintiff. It's on the person that's seeking a protective order. And it doesn't help in this particular instance that, the allegations that my client had, which I believe were valid, were the type of allegations that could have resulted in charges being filed against the defendant, and no charges have been filed. So that definitely didn't help either. So in the absence of charges being filed, in the absence of, if it involves kids, in the absence of DHS being involved in something like that, if it's truly just a he said, she said, that's never going to be enough to get a protective order granted, or in most cases, it's not. Let's say every now and then, maybe you got someone who's just absolutely insanely credible on one side and someone who just has zero credibility on the other side. Then maybe just, you say it happened, they say it didn't. Maybe that's enough to get you there. Unfortunately, in this case, it wasn't. The court said that disclosure was very credible, had no reason to disbelieve the disclosure. But just as much, the court said that the denial was credible and had no reason to disbelieve the denial. So if you believe the disclosure, but you also believe the denial, you know that someone's lying. In that instance, the court just cannot grant the protective order. There's not enough there for that. So if you're looking to get a protective order, you want to make sure that you're doing everything that you can to get enough evidence to prove that it happened. Not just say that it happened, but to prove it. Because ultimately, in the court of law, it doesn't matter what happened, it matters if you can prove it. If you have questions about this, or if you're trying to get a protective order, definitely give me a call. I want to sit down with you. I want to go through the facts of your case. I want to see what evidence you have and figure out what we can do to help. My name is Carl Birkhead. I'm an attorney with Worth Law Office, and I want to help you make law easy. Thank you.